In 2018, this legislature enacted and this administration ultimately signed into law the landmark Criminal Justice Reform Act, which modernized just about every aspect of our criminal justice system here in Massachusetts. It has been the standard for our country, with other states and the federal government incorporating many of its provisions into their own laws. As with all of our laws, none remain static. The legislature is continually examining the consequences, both intended and unintended, of the laws that we pass. We're continually striving to improve those laws, and to do so, we need partners in government who work cooperatively towards those goals. Sometimes we find those willing partners, sometimes we don't. It should not be an extraordinary statement for the legislature to say that when we pass a law, we expect that law to be enforced and implemented to its fullest extent. When we find that this is not the case, or have difficulty discerning whether that is the case, we have an obligation to inquire into specifics. And so that's what brings us here today, more than 4 years after the enactment of the CJRA. After hearing concerns from a wide swath of individuals, groups, government officials, and legislators alike, this committee undertook a substantive review of the implementation of the CJRA, as well as the overall operations of our corrections system here in Massachusetts, as operated by the Baker administration and the Commonwealth's 14 sheriff's offices. These hearings are a point in time, but somewhat of a culmination of that review. From research to meetings to formal letters, document requests, and ultimately invitations to appear before this committee, the review has answered some questions and raised others. The hearings come at an important time when we're transitioning from one administration to another. We have called these hearings for two main reasons. First, so that we can attempt to achieve some insight into clarity into what has been an unnecessarily opaque operation of our state corrections system. To highlight successful initiatives and steps taken by the Baker administration and its Executive Office of Public Safety and Security and Department of Corrections and our sheriffs, and to be clear about failures or continuing challenges in this area. Second, recognizing the fast approaching end of one administration and the beginning of another, we hope that these hearings will proactively identify the work remaining in our efforts to modernize our corrections system for the incoming governor and her team. In that spirit, we asked the Baker administration and our sheriffs to send us documents we hoped would elucidate some of these points. And we requested that they appear here today and tomorrow to address outstanding questions this legislature has in 4 general areas: data reporting, inmate welfare, corrections officer welfare, and the operation of Bridgewater State Hospital. We're pleased that our sheriffs took the request seriously by producing voluminous documents in a short period of time, and they will appear before us tomorrow morning. Unfortunately, this administration took a different approach. While their 14-page written response did indeed provide us with links to different sources that answered some of our inquiries and showed either full implementation of the CJRA or that we are on the road towards compliance in many areas, the written response in many instances simply ignored certain inquiries altogether. And the administration flatly refused to appear at any time over the next 2 days. It is incredible to me and a disservice to our government that this administration chose this approach. But nonetheless, I believe the hearings will perhaps demonstrate why they refuse to answer certain questions and refused accountability altogether on others. With that said,
we will now ask for the first presenter to speak, Lizz Matos, Executive Director of Prisoners Legal Services. Ms. Matos, thank you for being here.
Good morning, and thank you so much, Chairman Day and your staff, and Chairman Eldridge and your staff for the invitation to testify here today, and also for that great overview, which I very much appreciated myself. I also want to thank you for just recognizing the importance of having these oversight hearings today. My name is Elizabeth Matos. I'm the Executive Director of Prisoners Legal Services, and we, for some time now, have been calling for the establishment of an independent correctional oversight body. And today we'll repeatedly hear the justifications for such a body, and more importantly, why such a body must have enforcement powers. As we can all see, the DOC and most county correctional administrators are not in the room here today. They did not comply with the request to be present and answer questions as we are. And this behavior is, of course, illustrative of a repeated unwillingness to comply with legal mandates, particularly those that are the focus of today's hearing. And such behavior and violations persist precisely because there has been insufficient accountability. And today is certainly a step in the direction of looking at what the mandate is and whether or not the actions match the mandate. And I wish it would have been possible for you to hear directly from those who have suffered as a result of the violations of the laws that govern prison conditions in the Commonwealth. Many would talk about the endless psychological damage of months of spending 21.75 or 21.25 hours per day in their tiny cells with hardly any access to programming, visits, or phone calls. Despite the nationally recognized reforms that we passed here in Massachusetts in 2018. Family members would discuss how visitation has been severely limited and also contained to costly video visits in contravention of state law as well. Family members of our most elderly and debilitated clients would talk about their incarcerated loved ones and how they needlessly died despite squarely meeting the statutory requirements for medical parole. Failure to comply with the CJRA and other laws impacting incarcerated individuals has resulted in serious harm and even death. While it is important to recognize that efforts have certainly been made and resources have been expended to implement criminal justice reforms, the trend has largely been to either interpret the law to require as little change as possible, even when the language calls explicitly for maximization, or to ignore and thwart it. For example, Chapter 127, Section 39B of the CJRA requires several safeguards for those who find themselves in the DDU, one of the most restrictive settings in the country still today, where an individual can be sentenced up to 10 consecutive years in solitary confinement per disciplinary infraction. The DOC has failed to promulgate regulations since 2018, establishing standards and procedures to maximize out-of-cell activities over and above 5 hours per week, which is all the individuals who are in that unit still receive today. In addition, so there are about 36 people in the DDU today, so it's hard to imagine why more out-of-cell time cannot be managed by the department. In Chapter 127, 39B subsection A requires in-person reviews after 6 months, but the reviews are largely on paper from what we can still see. And this is important. It is not a minor detail. There was extensive debate and conversation about this particular provision when the CJRA was passed. And the reason it is important is because the intention was for the DOC to engage directly with the individual and discuss with them what their needs are so that they could both envision a path out of the DDU, given how incredibly restrictive the nature of the DDU is. This was the clear intent of the provision, and other safeguards to mitigate against the damage caused by this extreme form of solitary confinement were also passed as part of the CJRA in recognition that such an environment does none of us any good. However, provisions guaranteeing access to canteen items, visitation, and phone calls have not been heeded. For example, prisoners in the DDU are allowed only 2 phone calls in the first 30 days and no prison visits whatsoever. Ironically, the DOC also has oversight authority over the counties, but they have failed to promulgate regulations in that regard, as well as required by the CJRA. A poignant example of this, basically what I would call a trend towards the status quo in doing little more than that, is how the DOC has created a system of pseudo-solitary, basic pseudo-restrictive housing units called the Behavioral Assessment Unit, the Secure Adjustment Unit, the ITU at Framingham. These are also not just in violation of the spirit of the laws passed in 2018, but already existing law. subjecting individuals who are not under disciplinary sanction to conditions more restrictive than general population without good cause and without due process violates the kindness statute, which is chapter 127, section 32 of the law, and in violation of Blaney versus Commissioner of Corrections and Hoffer v. Fair. People confined to the BAUs are not there to be disciplined and therefore entitled under the reasoning in Blaney to equal treatment as to those in general population. But instead, outrageously, they're actually afforded even less than what those in restrictive housing are afforded today. In closing, I just want to mention that there are a number of violations from the counties as well. And specifically, Plymouth County, Barnstable, and Worcester County claim that somehow 22 hours a day, which is in direct violation of the black letter of the law, 22 hours a day in restrictive housing is somehow not in violation of the Criminal Justice Reform Act, and that has been an ongoing battle that we've had with the counties. I'm happy to answer any questions. Of course, I spoke a lot about restrictive housing because that has been a major area of challenge, but so has, as I mentioned, visitation, medical parole, and a number of other areas I know other colleagues of mine will speak to today.
Great. So thank you so very much, Ms. Matos. I appreciate you coming before the committee. And obviously, any questions committee members have, please direct it to the chairs. I do have a couple questions, and you phrased it as the DOC has created these pseudo solitary confinement units, including the SAU and STU, I believe, as well as the behavioral unit. And I'm just wondering if you could describe how those are those in violation of the solitary confinement laws the legislature has passed, and if so, how?
Yeah, thank you for that question. And the way I would answer that is certainly our contention is it's in violation of the law and of the spirit of the law. Certainly the idea was to minimize the psychological damage and impact on people of restrictive confinement, and reducing that time period by 15 minutes or 30 minutes certainly does not do anything to reduce the impact of solitary confinement on people psychologically or physically. So I think it's clear that it's in violation of the spirit of the Criminal Justice Reform Act. However, I would say in addition to that, there's a very clear argument that given the spirit and the intent of the law, in addition to the kindness statute that I mentioned, chapter 127, section 32, that of course it is nonsensical for these units to be more restrictive than the general population when they're not presumably not statedly established for punitive reasons, and of course for folks in the BAU to have even less protections than those afforded to people in restrictive housing under the CJRA. So I think the argument is clear that those units are in contravention of existing law.
Thank you very much. You and your staff of attorneys do incredible and obviously very difficult work advocating for incarcerated people. I'm wondering if you could talk a little bit or perhaps share a few examples of the psychological impacts of people in solitary confinement.
Absolutely. I think the report that came out by the Department of Justice in 2020 highlights some of the most severe impacts, which are suicide and irreversible psychological damage. We've had clients who I've spoken with personally on the phone and had in-depth conversations about their lives and the conditions that they're experiencing, and then they spend sometimes just months, which is an incredibly long time for any of us to imagine, in restrictive housing or in the DDU, and they cannot have a linear conversation because of the impact of that setting. And of course, we have to remember these are people who we know as a fact are disproportionately impacted by trauma and abuse before coming into the prison context, and who have serious mental health issues, right? As people are struggling with substance use because of underlying mental health issues that haven't been addressed and trauma that hasn't been addressed. So being in a cell locked up for even 20 hours a day is incredibly unhelpful, because we also know that access to adequate mental health care is seriously lacking across these systems. And so the harm is, even if you were to isolate, just having somebody in isolated confinement for that long is problematic. But then given the layers of issues that we're dealing with this population, it's particularly unconscionable. So we have seen, as I've said, people self-harming a great deal. And that is also documented in many reports in terms of the impact of psychological torture that's caused by solitary confinement and restrictive confinement, even 21 hours and 20 hours per day. People self-harm, people hang themselves, they try and kill themselves in any number of ways. Of course, there was two unfortunate suicide attempts in Bristol County just recently of people who are being held on mental health watch, which is used, as the DOJ report very conclusively stated, as a punitive restrictive housing placement and should be considered restrictive housing. So I think that is unfortunately the most extreme form, but it's also the most common form of damage, that manifestation of psychological harm that we see, which is the self-harming and suicide attempts. And on a lower level, like I said, just an inability to really function, to have conversations, to hold a thought. And people will recognize that. We'll be in the middle of an interview and they'll say, I'm sorry, I lost my train of thought, or incredibly fidgety, very uncomfortable, can't maintain eye contact. A lot of the symptoms that clinicians have laid out in their studies on this issue as well.
Thank you very much. And I'm wondering if you could explain what is the range of infractions that can lead to someone being placed in solitary confinement by the DOC? Sure.
Well, it's any number of things: refusing in order to move to another cell, getting into a fight with someone, blowing up verbally at a staff member. It's really a range of things because it's unfortunately pretty discretionary. So it can be serious things from, having contraband in your cell, or having an item that you shouldn't have, or having other kinds of interactions you shouldn't be having in contravention of rules. And it can also be very minor things. Like I said, interactions that are not appreciated by a staff member, or just not refusing a housing order is another one that comes up, especially for people with serious mental health issues. Sometimes there's a lot of paranoia involved in why someone is being moved, or fear about being physically moved into another unit. And that's oftentimes a reason for somebody to be placed in solitary confinement or restrictive housing. Another, unfortunately, is when someone reports staff assault to us. Oftentimes they are placed in restrictive housing immediately after the staff assault. And there are many reasons for that we could talk about separately, but that is often a consequence of reporting a staff assault.
Thank you. And my last question is, you mentioned the regular review that is to be done by the DOC with the legislature's intent to reduce and ideally eliminate solitary confinement, but that it's, I think you said, somewhat of a rubber stamp. If you could talk more about what that process is and how you and your fellow attorneys experience it.
I'm sorry, about the grievance process?
Yes, the review of a person being in solitary confinement.
Oh, the reviews,
Yep. Mm-hmm.
Yeah. Well, at first, the reviews aren't really happening. And I think after some time and some of the work done in the Restrictive Housing Oversight Committee, the reviews are happening in a number of other contexts. In the DDU, however, there was a particular process laid out there. It was a little bit different, that after 6 months that there should be an in-person review that was more of a back and forth about what exactly was happening with the individual, what programming or other rehabilitative needs they might have, and how to engage in some programming or activities that could help carve a pathway out of the DDU. And we have not seen those happening. Those are largely paper reviews, which is very similar to a process outside of the DDU. But they have not been happening as envisioned by the CJRA and really as explicitly laid out in the CJRA, the process that should be happening for people in that particular restrictive setting.
Thank you very much. Chair Day.
Thank you for your testimony, Ms. Matos, and for appearing today. Questions from some of the members of the committee. Do you have DOC suicide attempts and actual rates of suicide of inmates? Are you knowledgeable of those? And is there a facility or a set of facilities that are outliers, that are more than others or significantly less than others? Could you just opine on that?
Sadly, I think it's in terms of the DOC, I'm not sure there are outliers. I think it happens across facilities. There's a mental health unit at OCCC. We certainly have had, in some ways there should be, because of the mental health unit and the resources there, you'd hope there'd be less of that, but that hasn't really seemed to be the case. Of course, Susan Baranowski is particularly problematic, especially since the north side and the transitions that happened after the assaults in January of 2020 became basically one part of that facility essentially became a supermax prison, and it's very problematic issues there as well. Similarly, people have less access to things than people in restrictive housing do. So that is another area where people are really decompensating, that we've noticed that. The DDU, of course, there has been a long correlated history between segregated confinement and self-harm and suicide attempts. And so Mental Health Watch, which was the subject, of course, of the DOJ report, but also any more restrictive setting is almost always more highly correlated with self-harm, self-injury, and suicide attempts and suicides. So that, because we have those units across the department, we see that. But of course, the DDU is perhaps more concentrated, as are other mental health units. And then in the county context, I think there has been, of course, ample reporting about how Bristol County is an outlier there, but I would say Barnstable County is another facility to be looking at. There have been a number of problems there. For example, they've had a long practice of leaving the lights on 24 hours a day for people, and that has really had an impact on individuals in that facility that we've heard about repeatedly and done advocacy on, but without success. So I would say in terms of counties, Bristol County and Barnstable County, and in terms of the DOC, the most restrictive units across the system are the ones to be looking at.
And a few questions on the DDU in the DOC. Do we have any numbers or statistics on how many inmates are refusing to leave the DDUs?
We don't have statistics on that, but my understanding is the issue is not that people, that there is a significant number of people who are refusing to leave the DDU, as much as a lack of a pathway out because of what was discussed before. Since they have these disciplinary sentences, they have to stay there for a particular period of time unless there is a pathway out, which under the CJRA for the first time, that was carved out in the law, that there was an ability to carve a pathway out of the DDU prior to the expiration of the disciplinary sentence. But that has happened in a few cases. I want to recognize that the administration has moved some people where they've recognized this person doesn't really need to be here anymore. We have one particular client who spent about 2 decades in the DDU who is no longer there, thankfully. And so that did happen. But by and large, our understanding is that those reviews are not happening so that the pathway out is available on a wider scale. In terms of other people in restrictive housing refusing to leave, I think that does happen, and for a number of reasons. In my personal experience with clients, the level of psychological decompensation is so severe that it's a level of paranoia, of just feeling incredibly unsafe to leave the cell. So that's one. The other is if someone has been a victim of assaults from other staff or other prisoners and has felt that the department's been unable to keep them safe, they often will also be unwilling to leave the cell because they are afraid to be housed with other individuals. Occasionally, we have seen particularly vulnerable people, particularly maybe trans or people who are have been identified as openly gay, also be afraid to change housing placements because their safety has not been adequately protected in other contexts.
And forgive my ignorance on this, and I'll confess it. Aside from anecdotal and actual stories that you've got, are these numbers collected anywhere? Is there any aggregation or data repository for this? Is there a reporting requirement on this scenario?
For which piece? Sorry.
For the refusal to leave the DD?
I have not seen that, and I looked recently at the restrictive housing reports. I did not see anything in the report by the DOC documenting the refusals myself. So to be honest, I 100% don't know, but I would think it would be in that report. And so since it isn't, I don't think it's publicly, I would say it's probably not publicly available. I'm not sure that it's actually being documented by the DOC in a way that could be accessed.
Another question from a member. With respect to the DOC's interpretation of the DDU, have there been any lawsuits, to your knowledge, filed about that change of interpretation, that change of classification of DDU?
I'm not aware of any. There is one lawsuit actually that the Boston College Clinic has that relates to the DDU. But I'm not aware of any other lawsuits on the violations of the in-person reviews.
The follow-up question was, do you have any recommended legislative fixes? Is a little bit of a softball for you. Do you have any legislative fixes recommended to prevent future changes of this sort?
Yeah, absolutely. Thank you so much for asking that question. And this relates to, I think, the points that were raised in your openings. When we survey clients, and I hope, I think it would be really wonderful for the legislature to survey people inside as well. The major complaint we hear from people is idleness. They do not want to be idle. They want access to programming. They want to be busy. They want to be doing things. Particularly at Sousa, this is a major problem where there's a lack of programming and access to education. That is a huge issue and leads to a lot of problems when people are spending a lot of time being idle and don't have opportunities to focus on other things. They're left with, again, the trauma and mental health issues and lack of treatment, separation from their families, and all of those things that make getting by day to day much more challenging. And so the busier people can be, the better. There is legislation that we are working with folks on for next session that would provide baseline access to programming and out of cell time and education. We think that would actually make a huge impact on the conditions and daily living for folks inside, and greatly reduce, that has been proven to do in other states, incidents that require more restrictive security settings.
Thank you. And then separate topic question from a committee member. Could you speak to the status of the free video calls that were provided to inmates during the pandemic? What is, to your understanding, is there a plan moving forward for the provision of that, continuation of that service?
Yeah, thank you so much. During the pandemic, our understanding is it was a bit all over the place in terms of what counties offered and what the DOC offered, but for a period of time, not for the entire duration of the pandemic, and certainly not now. But many facilities offered like free phone calls per week. I think the DOC was doing that as a matter of course for some time. That was at times, I think, being subsidized, at least partially, by Securus or GTL, and at times being subsidized by the actual prison, the DOC and the jails. However, my understanding is that it's not being offered now. We have not heard of that. And people continue to pay for phone calls. And going forward, of course, our office has been very clear, as have others, that this is a predatory practice that should never have existed to begin with. The fact that people and families are being charged to be connected is incredibly problematic, especially when we have the state of Connecticut now, the state of California, and a number of municipalities offering this service to far greater populations, incarcerated populations, for free. And is far less costly to do so when there is actual competition, which is right now, I think, as many of you know, there is a commission. A lot of the contracts are based on the commission rate, which drives up the cost of the phone calls. And so the sheer way that these contracts are negotiated leads to a predatory practice and basically profiting off of some of our most vulnerable families in the Commonwealth. So going forward, we would recommend that calls be made absolutely free to families and those incarcerated, and be considered as the other things we've been talking about, like visitation, as a cost of conducting corrections and rehabilitation in particular, since it has been very squarely correlated with positive rehabilitation. And on the visitation issue, for example, I just wanted to highlight that it was important, I think, for the department to offer video visits during the pandemic, but there are charges. It's 6 minutes for, I think, 15 minutes. I mean, it's $6 for 15 minutes and $20, I think, for a half an hour. And that's incredibly costly for families, and at times was the only option. But existing law, mainly the Sousa case that we litigated many years ago, as well as the Criminal Justice Reform Act in Chapter 36C, Section 36C of Chapter 127, said that you can't charge for visitation, whether it's video visits or in-person visits. You shouldn't be charging for visitation, and so that should also be free of charge.
Great. So Ms. Matos, thank you very much for coming before the committee. Greatly appreciate your time, work with Prisoners Legal Services.
Thank you very
Thank you.
much.
The next person to come to testify before us regarding women's prisons, Sarah Nawab, Director of the Women's Incarceration and Reentry Project of Prisoners Legal Services. Good afternoon.
Good afternoon.
Thank you for coming before the committee.
Thank you so much for inviting me to testify. Can everyone hear me okay? Thank you. My name is Sarah Nawab. I am an attorney with Prisoners Legal Services of Massachusetts, and I am the founder and director of the Women's Incarceration Conditions and Reentry Project. PLS's Women's Project interviewed and surveyed several incarcerated women and published their anonymized experiences in a comprehensive report called A Different Way Forward, released this past July. The report details incarcerated women's stories around violence and trauma, mental health, and identity-based discrimination. The overwhelming majority of women interviewed and surveyed reported that they had either experienced or witnessed sexual misconduct or harassment by correctional or other staff. Women also reported experiencing physical violence and threats of violence by prison staff, as well as verbal bullying from staff. Women throughout the Commonwealth reported pervasive retaliation for reporting staff misconduct, and several women reported that they had experienced physical and sexual violence prior to incarceration as well, indicating that incarceration is creating compounded trauma. Women also reported experiences and conditions in Massachusetts prisons and jails that have exacerbated mental illness, and also reported that mental health care is woefully inadequate to virtually non-existent. We've already heard a little bit about transgender people's experiences. I'll just add to that. Transgender women incarcerated throughout Massachusetts reported a lack of access to gender-affirming healthcare and gender-affirming resources and programming, and reported spending extended periods of time in solitary confinement. Transgender women also reported undergoing unclothed searches conducted by male officers, despite having specified their preference to have female officers conduct those searches, and also reported experiencing harassment based on their transgender status. Incarcerated women who are Black, Indigenous, and people of color, or BIPOC, reported issues of racism. Some women reported that officers engaged in overtly racist behavior, including using racial slurs. BIPOC incarcerated women reported experiencing job discrimination and worse medical and mental health care as compared to white incarcerated women. BIPOC incarcerated women with English as a second language reported struggling to be heard, understood, and addressed due to inadequate interpretation services. Black incarcerated women reported that the canteen does not carry hair, skin, and hygiene products appropriate for their skin type, hair texture, and health. Currently, the Commonwealth appears to be pursuing plans for a new women's prison, claiming that it will be, quote, trauma-informed, but this is the wrong solution because there is no such thing as a trauma-informed prison. Much of the harm that both cisgender and transgender women face at the hands of correctional staff is in contravention of law and yet continually occurs with impunity, indicating that the violent and punitive culture that enables harm towards incarcerated women is endemic to prisons and jails. The surveillance inherent to incarceration, particularly when exercised by men with state-sanctioned authority over women in custody, is traumatic. Previous attempts throughout the country to incorporate trauma-informed practices into women's prisons have failed, demonstrating how such practices are diametrically opposed to prisons and jails, where violence and harm are inherent to operations. To adequately respond to and remedy the harm women face in these systems, we must reduce reliance on punishment, decarcerate women as possible, and shift resources to community-based systems of care that are equipped to support human dignity and healing. This work begins with passing a prison and jail construction moratorium and redirecting funds aimed at building a new women's prison to community systems of care and safety that will prevent harm. Thank you, and happy to take any questions.
Great. Thank you very much, Ms. Nawab. I appreciate your testimony. Just have a few questions. The survey experiences you talked about is for the women at MCI Framingham. Is that correct?
I sent it to women throughout the system. MCI Framingham, also county jails that incarcerate women, and also to transgender women in men's facilities.
Okay. For women in correctional facilities in Massachusetts, what specifically are the facilities that they're at now?
With DOC specifically, it's only MCI Framingham for, as a designated women's facility. There are, again, throughout DOC, women incarcerated in men's prisons because they are transgender.
Right, and I understand the transgender point, but then what are the county facilities where women are held?
Sure, there are a few. There is Suffolk. There's also Western Mass Regional in Chicopee, Franklin, Essex, and Bristol, I believe.
Okay. With respect to MCA Framingham, which has been a major focus of the legislature, including the prison moratorium bill that you mentioned that the legislature did pass, but Governor Baker vetoed. So is there an awareness for the women at MCA Framingham about the potential closure of MCI Framingham and their preferences about where they would like to see themselves, if you will?
Of course. So obviously the women in Framingham are not a monolith, so opinions certainly vary. There is, of course, an awareness for those women that MCI Framingham is extremely dilapidated, and it's not sustainable to stay there.
Any discussion about educational programs at MCI Framingham or what they are?
Right. For the most part, they've been shut down. Women over and over again, when I speak to them, I'll say, well, what's the programming looking like? And I'll hear back, what programming? It's not accessible. And to the extent that it is, it's very hard to get into. And there are limited options for programming. There's also programming that existed in the past, including educational programs and cosmetology that are no longer available to women inside. And at this stage, they can't get degrees in Framingham. They can only get certificates.
I did not know that last piece. Okay. You'd mentioned about job discrimination, and I've certainly heard from male, Black, and Latino incarcerated men about job discrimination they experience, obviously, in other facilities. Can you talk in more detail about the job discrimination against female incarcerated women of color?
Sure. It generally comes down to those higher paying jobs that give the kind of experience that you want, that they are not as considered for as their white counterparts.
Okay. Are there specific jobs, just curious, that are the more desired jobs? I'm not sure if you'd know that.
I'm not sure offhand, but I can find out.
Okay. Thank you very much. Those are all the questions that I have. Chair.
Thank you, Mr. Chair. Thank you for your testimony and your work. We read through your July 22 paper on a different way forward. And thank you for your work on that. There's a section there where you're discussing the case files of instances of sexual assault, sexual harassment that have been reported and created. You had to go through the FOIA process to retrieve those. We had asked the administration for the copies of those files, which are ultimately public records, and received in response a reference to a different commission from the Ripples, or a report from the Ripples group, which we already had access to. And I know in your report, you said you wanted to be sensitive to the identities of the individuals, which we respect. Could you give us a sense of numbers of case files and what the extent is that we're looking at?
Sure. I mean, it was hundreds of pages of records that I received when I went through my records request. What I asked for was, I referred to a very specific PREA report. Every year, DOC releases a PREA report, usually in the spring, detailing all the PREA reports. PREA is the Prison Rape Elimination Act. All the PREA reports from the previous year. And what I did was I looked at the ones at MCI Framingham for the 2019 report. And I asked for all the PREA allegations and reports from staff misconduct towards incarcerated women. And I received hundreds of pages of reports. I'd have to look into the report itself to see precisely what the number was of reports that I received. But there were hundreds of pages of records that I went through for that.
Thanks.
Great. So thank you again for your testimony coming before the committee.
Thank you very much
Great,
for inviting me.
appreciate
I appreciate it.